we have anyone ready to fill the court? Do we have anyone ready?
Mr. Versace is ready. Yes, Your Honor, we do have a couple of attorneys ready. Mr. Versace?
All right, this is cause number CR 11-45, State versus Efren Stewart. Mr. Stewart said on his motion to revoke. We need to set this for a contested hearing, Mr. Versace.
No, Your Honor, I believe we could set this out for a plea. We're trying to get some matters taken care of, and we do have a plea agreement at this time.
Okay. How long of a reset are you asking for?
If we could get about at least a month, if possible. My schedule, I am out the last 2 weeks of May into the first week of June.
June 13th?
I believe I can do the 13th.
All right, so you're telling me we do have a plea agreement?
Yes, we do, Your Honor.
All right, the court sets Mr. Stewart then to enter his plea before the court on June 13th. Is that a plea for time or for probation?
It will be a time offer.
All right, so that'll be at 1:30.
Thank you, Judge.
You're welcome, sir.
Right, Mr. White.
Richard Balboa, CR 22-124, CR 22-369. Show that Mr. Balboa is set for pre-trial on evading arrest or detention of vehicle, and then arraignment on bail jumping.
Your Honor, if the court will recall, I was retained on this case about 10 days ago. I was unable to be here because I had a procedure that day. As far as we can proceed forward on the arraignment, I've had a chance to review the indictment. Mr. Balboa is the person named in the indictment, and we'll enter a plea of not guilty in the bail jumping case.
Okay.
Then,
All right. Go ahead.
and then as far as the other case goes, the DA's office is, I've talked with Ms. Melton, or my office has, and she's getting us the videos on this matter on the evading.
All right. All right, court will enter Mr. Balboa's plea of not guilty into the record for bail jumping. Court will find these waived the formal requirements of arraignment. We'll set both cases to run concurrent on pretrial. Mr. White available on, I'm not sure if I set you earlier today or not.
We were set on June 15th, Your Honor.
We'll set Mr. Balboa on June 15th as well at 1:30 if he's in custody, 9 a.m. if he's on bail. Mr. Lowe. Is that all you have, Mr. White?
I have a plea, Your Honor.
Okay, well, that's fine. We'll do that in just a second. Mr. Lowe, I want to talk to you real quick regarding Mr. Gerard. I think that you've talked with Deputy McLeish. She's given you some information about Mr. Gerard. Is that true?
That's correct, Your Honor. I've asked for him to try to bring him in here. I know that he could be disruptive, but he started his medication, I think about 3 weeks ago after we had the hearing. I think he's a bit improved, but he got to the point where he's improved enough to fire me. So, if he's able to come in here, maybe he's better today, Your Honor. I don't know. If you want me to stay on the case, I can. I'm not sure it's going to go anywhere until he actually gets where we can communicate. But he did fire me the last time. Last time I talked to him, and the jail staff said he was pretty agitated.
Yeah, so really all I wanted to do was decide whether or not we needed to bring him up for this hearing or not. So let's do this. We will get the other inmates cleared out. We'll bring him in by himself. That way, if he becomes an issue, they'll be able to address that without having safety of other inmates.
Okay.
So, all right, we'll call him up.
Your Honor, I'm sorry, I stepped out, so I missed a part of that. Mr. Lowe and I have already been in communication about this, and if it's okay with the court, if we could take care of Ms. Short, then I think we're ready to go ahead and accommodate him.
Yes, yeah, that's what I was saying. I was telling him that we'll get the other inmates done, and then once we get the other inmates done, then we'll bring Mr. Short.
Okay, thank you, gentlemen.
All right, I'm sorry, Mr. White, Ms. Short, if you'll come up. This is CR 22-393, State versus Hannah Marie Short for arraignment. Go ahead, Mr. White.
Your Honor, at this time, we'll waive formal reading of the indictment. Ms. Short's the person named in the indictment. She knows what she's been charged with. Pursuant to an agreement, she's going to enter a plea of guilty at this time, and we're going to proceed forward.
Okay, what are the terms of the plea?
Your Honor, in exchange for Ms. Short's plea of guilty, the state's going to recommend 5 years in the Texas Department of Criminal Justice Institutional Division, $1,000 fine, $180 restitution, court cost, and the state is going to 1245 DA number 2022-0984, which is a possession of marijuana in an amount greater than 2 ounces but less than 4.
So it's a straight 5 years to do.
Yes, sir. There's also 188 days credit.
188 days credit. Any reimbursements?
There is a $105 reimbursement fee, Your Honor.
Okay. All right, Ms. Short, if you will raise your right hand, I'm going to place you on oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. Ms. Short, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
I've been diagnosed with PTSD and severe depression and anxiety.
Okay. Are you currently on medication or undergoing treatment for those?
Yes, sir.
Okay. Do you feel like you have a rational understanding of the proceedings and what's going on here today in court?
Yes, Your Honor.
Okay. And you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney?
Yes, sir.
You feel like he's giving you time to have all of your legal questions answered about your case?
Yes.
Is there anything about the paperwork that you've read over and signed today with Mr. White that you don't understand?
No, sir.
You heard Mr. White read the plea agreement to the court, is that right?
Yes, sir.
That's what you're asking the court to approve today?
Yes, sir.
Ms. Short, I do have to admonish you that you are charged by indictment with a second-degree felony offense of manufacture, delivery of a controlled substance, penalty group 1, greater than or equal to 1 gram, but less than 4 grams. And it does have a range of punishment of not less than 2 years in prison or more than 20 years in prison. It carries a fine of not more than $10,000. So at this time, Ms. Short, understanding the plea agreement, understanding the range of punishment, how do you plead to that crime?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, Your Honor.
Has anyone threatened, coerced, or pressured you to plead guilty?
No, no, sir.
The court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
The defense?
No, sir.
All right, state, can you give me the evidence to support the plea?
Yes, Your Honor. On August the 11th of last year, DPS made a stop on the car that Ms. Short was driving on I-20 for speeding. Immediately, the officer can smell and see marijuana in the car. In plain view, he asks Ms. Short if there's anything else illegal in the car, and she tells him that there is a bag in the back that has some additional excuse me, Judge, additional narcotics in it. The officer gets it out. There are, I believe, approximately 14 ecstasy pills as well as marijuana. She tells the officer that she only does marijuana, but that her dealer gave her some ecstasy pills to make a little extra money because he knew she was down on her luck. The lab tests half of the pills and it comes back 1.57 grams of meth.
Thank you, Ms. Heisel. Anything further, Mr. White?
No, Your Honor, that's accurate.
All right. All right, then based on the evidence presented to the court finds that Anna Marie Schwartz is hereby found guilty of manufacture and delivery of a controlled substance of Group 1 between 1 gram and 4 grams, a second-degree felony. The court will follow the plea agreement reached between the defense and the state. Court hereby assesses her punishment at 5 years confinement in the Texas Department of Criminal Justice, orders her to pay a $1,000 fine, $180 restitution, $290 in court costs, $105 in reimbursement. Court also 1245 dismisses DA 2022-0984 possession of marijuana. The court awards Ms. Short 180 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Short, you hereby remain into the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'd like to.
Your Honor, very
Thank you.
quickly, it was 188 days credit, and the judgment reflects that. I believe you said it. You kind of cut out on us. I didn't know if you said 180 or 188.
I've got written down 188. Whatever the record reflects, it should now reflect, if it doesn't already, 188 days credit towards her sentence.
Thank you, Your Honor.
Sir.
Thank you. Thank you so much. I'll let you know when I get in. Okay.
Mr. Manning,
Yes, Judge.
I'm discussing with Ms. Taberham, but on Aaronville,
Yes, Judge.
so he's gonna be going to a VA facility.
Correct, Judge. There's a VA residence, homeless shelter in Dallas that he is, as part of his conditions in Rains County, as well as his conditions here in Van Zandt County, been ordered to attend. And so the issue was that they were unable, we requested a courtesy transport from the sheriff's department. They agreed to that. They're unable to do that until Thursday. We would like to go ahead and do the plea today. And as part of his conditions of probation, just like with safety, that he would remain in custody until such time as he is transported by the sheriff's office to the VA facility in Dallas.
Okay, so you said it is a condition of his community supervision that he attends that facility.
I'm sorry, Judge.
Said that it is a condition of his community supervision that he attend the VA facility, that he reside in the VA facility.
That's correct, Judge. He is homeless and has been so for quite some time. And so as part of this deal, as well as part of the deal he got in Rains County, he is getting assistance financially with being on probation, but he's also being required to go over there to reside at the VA facility. They're going to help him get back on his feet with job and classes and mental and physical evaluation.
All right. So the sheriff's office has agreed to drive him to Dallas on Thursday.
That's correct, Judge.
He's just agreeing to remain in custody because I'm questioning the legality of us being able to hold him.
Judge-
Without some kind of order. I see safety is different because that's a state-run prison facility. VA is not state-run.
Correct. Judge,
So-
you-
Go ahead.
the reason we were wanting to proceed today is because he has to get over there by a certain time to be able to get into the program. They close at 3 o'clock in the afternoon, and he would be unable to do so if he were released from jail after pleading on Thursday afternoon. There would be no time for him to be able to get over there in time. And we actually ran into this problem last time that he was here. And he was released to go there, and he was unable to go there, and actually ended up kind of just wandering around town. And so both my client and the sheriff's office are in agreement that he is fine with waiting here until Thursday. Like I said, as a condition of his probation. If we want to make it more formalized, we can just say that he's to serve 2 days to do as a condition of probation, and his 2 days to do would be today and tomorrow.
Whether we do that or he just waives on the record any objection being illegally confined. That's my only concern, is that there's a complaint later, and then I don't believe that any of us would have the defense of saying that we had some kind of legal means to. Like I said, I'm not certain on this. I just question it. So I'm fine with the arrangement that you set up, and if the sheriff's office is willing to drive to Dallas, they don't have to help him, that's fine. I'm fine with that as well. I just don't want to create a problem later. So it'll be clear on the record that he's waiving. He understands that he could be released from jail today. And he would not get the benefit of being transported. If he will put that on the record, then I'm comfortable with it. If the sheriff's office wants to do that out of their discretion, I'm not ordering them to do that. They're doing that of their own free will.
Correct, Judge.
Okay, all right. Just want to be clear about that. So we'll discuss all this on the record again when he gets up. We'll give Mr. Lowe a few minutes if he needs to talk to his client.
Okay. I think we're ready, Your Honor.
Give me just a few minutes though.
Yes, sir.
Outside 11. Inside 11, that's F1 1.
Deputy McLeish operating with Mr. Lowe is, but no rush if he needs time. He has it.
We're ready.
All right, this is cause number CR 22-67, State versus Robert Gerard. Mr. Gerard, how are you today, sir?
I'm not too happy, sir. I've had a lot of legal things done to me in the way of this court today, just from the day backwards until the last time I saw you. Pre-trial motions, God ran so many pre-trial motions over me without me being in court, that it's illegal. And then he comes in today without me even knowing I have a court date, and pulls me in the court without even having any paperwork that lets me know that I'm ready for court. You're supposed to at least give me 10 days before, on a pre-trial motion before court.
I understand. And so, Mr. Gerard, Mr. Lowe is an attorney, and he's been appointed by this court to help you, to represent you. And so the court has been in consultation with Mr. Lowe regarding settings. And so Mr. Lowe has had advance notice of this so that he can represent you on these matters.
Not with me, though. He hasn't been in contact with me.
Okay, we'll talk about that. Mr. Lowe, any announcements for the court? I know we're just here today on a status, and I had my coordinator, Ms. Abraham, check Mr. Gerard's status for the wait list, and he was number 930 as of April 13th. And so any other information that the court needs to be aware of in this status?
So, Your Honor, we met last week. I think that Mr. Gerard he's on medication. I know he's on medication. It was forcibly administered to him. And I think he's doing better, but I don't think we're there yet. And I don't think he's really happy with me. But there's really nothing that
No, you're doing your job.
there's really nothing that I can proceed with until we have a resolution of this competency issue, Your Honor. I think he has defenses to the case as it's filed, based on the discovery I've looked at, but I would certainly not go to trial until I where I would be confident that he could assist me in his defense, and he's not there yet. But, so he did tell me that I was fired last time I was talking to him, but I don't know if he recalls that.
I don't remember that.
He doesn't remember that, but, I'm certainly willing to stay with the case until he says, till you say, or he says that he doesn't, that I don't need to be his lawyer.
So can I ask how y'all understand competency works? Because when you're incompetent, you're supposed to go through pretrial motions. You're supposed to halt all motions. And y'all ran 3 over me since my incompetence stand trial. Y'all had 3 court dates since then.
And what are those pretrial motions that you're referencing?
Y'all came and told me that I was supposed to come to court, and then y'all came and told me not to come to court. That's illegal twice because I was not supposed to have a competency trial while I was incompetent. And then y'all didn't let me come to trial, which is that according to pretrial is illegal. I'm supposed to be at every pretrial motion. So
Mr. Gerard, so let me intervene. So, Mr. Gerard, the only hearings that we've had since your finding of incompetency have been about your competency. It's been about medications. It's been about making sure that the law has been met with regards to forced medications, whether you're going to take them, whether you're not. You're meeting with the doctors who evaluate it. There's been no legal motions, no hearings held on any legal motions between the court, the state, and the court, and the defense at all. So the only hearings that we've had in the times that you haven't been in court have been at times when you have been at all times incompetent, and then either physically able to come to court, willing to come to court, or not willing to come to court. Some of these things you may not remember. I don't know. So I want to assure you that there's been no legal motions discussed, argued, had outside of your presence. Okay, everything that has been discussed has been about your mental health, your potential hospitalization, and your medications that have been prescribed. Okay, so what else that you have that's concerning?
You gave me a new charge. I got a new charge for first degree aggravated assault on a public servant. I never assaulted anybody. And it's not a first degree felony when I look it up.
State, has Mr. Gerard been indicted for any new charges?
No, Your Honor, he is not. I do believe he was arrested for a new charge, but we have not presented that to a grand jury. I don't believe at this time we intend to do so, given his status, until we see kind of how the other charges go. But I don't believe that we will be likely indicting him at this time, given his mental status. We do have it. We do have a lot of statute of limitations still pending, but at this time we are not planning on presenting it in the immediate future.
Thank you, Mr. Woodward. Mr. Gerard, you were going to say something?
So I guess he's asking, is there a bond? Is there a bond showing on that unindicted?
It's 90 days. It's 92. We're at 93 days now. And we have a 90-day. We're at 90-day indictment of that charge.
Judge, I believe he is, there is a bond on, there was a bond set on that at $100,000. And Mr. Lowe and I can discuss, I'm sure we can agree to something on that.
The bond is at $1,500,000 is what they have showing on in here. And I don't know how it raised from 100,000 to $1,500,000. I think it's wrong.
All right, well, let Mr. Lowe and Mr. Woodwhite talk about that after our hearing today. You're not indicted for that charge, and it's not before the court at this time. So any discussion on your bail and stuff, Mr. Lowe can do that on your behalf, and then he can communicate with you what the state says. But you are correct. I do believe that new charge was brought against you, but you've not been legally charged in court with that. So you're right on that, Mr. Sharp.
Yes, sir. And I am at 100,000. It's not supposed to be at $1 million. It jumped from 100,000 to $1 million. It's supposed to be at 100,000, right?
You know, I'm not sure. I haven't gone back and reviewed the record on that. I could look at that after court today, and if there's been a mistake, we'll certainly take care of it. But I believe that Mr. Lowe and Mr. Woodwhite will be able to work it out to where it's accurate.
Okay.
Okay. All right. So let me ask you this, Mr. Gerard. Tell me about your medication.
I just sleep all day.
Yeah. Are you taking the medication, or are they having to force you to take it?
They forced me to take it. but I've been waiting on a bed at the insane asylum is what they're saying. And so I'm waiting to go talk to a professional, because she's not a professional psychologist. And that's how the rules are stated to me for incompetency and competency to stand trial. And so when I read that, I said, well, I want to do it right. So I wanted to go talk to a psychologist and then get it right.
Sure. So what I want you to understand is that the medication that has been prescribed by a doctor. And the medication that they're telling us that you need to take is medication that we think will help you gain competency so that you can get to that hospital either A, quicker, or B, not at all. And then once you gain competency, then we can move forward on your charges so that we can get a resolution one way or the other, okay?
So, I don't know if you heard this to start off, the judge told you that there's a waiting list, I think you said.
No. What are you trying to? How's it going for me?
Well, so we got two issues right now. We got an issue over a bond, and he may be entitled to some relief on that bond for the aggravated assault.
Okay.
The other issues on the charge of murder, the court's already found you incompetent, but the court, remember, but he said that there's a 7-year waiting list.
Not guilty by accomplice.
7-year waiting list. But what he's hopeful to happen is that with the medication,
Okay.
that you get to the point where
I don't
we
know.
can go your trial.
I don't know how to say that because I'm not a psychologist. You gotta have a psychologist to evaluate me, to tell you all that.
Okay, well, I think that
I'm
there,
not a psychologist to tell you. Do you understand that?
I do.
Okay, I was just making sure you
So
understand.
my suggestion today, Robert, is that we work with the district attorney's office to get this bond issue resolved on the aggravated assault. And we wait and see how you're doing, and maybe come back in a month or so and see how you're doing on the medication, and I'll come talk to you, and then we can come tell the judge how you're doing.
Okay,
Would that work for you?
that's the way,
Okay,
I don't know. I really want to talk to a psychologist.
well,
That's the
they have
expert.
a contract with the Andrews Center, and perhaps we can get them, the jail nurse to call over.
I need to talk to that psychologist at the Andrews Center. That's like the closest one.
Right.
I'm thinking, well, I need to at least talk to him before I even say anything.
Well, I'll work on that with the jail. So I'll work on that with the jail
Thank you,
yard. See, we've had issues getting psychologists to visit with folks here, so we'll work on that with the jail to get where he can Zoom, or I don't know if they can come over here, but we'll look at this again in a month or so, Your Honor, and see where he is with the medication. Perhaps we get a psychologist to talk to him. So
I think what Bo is proposing is a good plan, Mr. Gerard, and anything that we can do to help with the Andrews Center to see if someone that can talk with Mr. Gerard, ease his concerns, we're willing to do that. All right, so let's put another date on the docket, Mr. Gerard. I'm gonna see you again because I want to keep seeing you and checking up on you and seeing how we're progressing. I want you to consider though, Mr. Gerard, I want you to consider strongly taking the medication voluntarily, okay? Because I believe this medication will help you to get you to the point to where you and Mr. Lowe can go to trial and you can urge these defenses that Mr. Lowe has talked about. But until we get there, we're just going to kind of be in the same situation. So I want you to consider doing that instead of having to make the jail staff hold you down and do it. We don't want to do that, okay? And these doctors believe that if you'll do that and cooperate with them, that it will get you to the point to where we no longer have to have that at all. Okay. All right. So Mr. Lowe, if you got your calendar, let's set it. Let's set it again for about I got June 27th. Are you available? That's a Tuesday.
$27. I've got
Yes.
$27. I
Yeah,
think it's 27, but 27, I can do 27.
27, yes, June 27th, 27. At 1:30.
All right.
Thank you, Mr. Lowe. I appreciate you being here today. Thank you, Robert. We'll see you soon. Thank you, sir.
Just give me a second. Okay. I didn't give it to you.
You know what I was saying? You know what I said? I said it was useful. Maybe here, yeah, take it. You understand what I'm saying? It's supposed to be a vote. Thank you. Thank you. Okay, I thought.
Guys, we're bringing Mr. Davis up. And then after that, we're gonna get back on our regular roll if that's okay. That's what I'm.
Even better.
Like that one.
Guys, I'm not sure that we're muted also.
Yeah.
Thanks.
So, what's that? You know that we haven't had a chance to discuss what I'm saying. They scheduled my all these court dates, but I ain't told you. The day. It's the day that I do that. I got it. I don't know. So it's up to you. We can ask that and say, but you might have an opportunity. And look at things that wants to have. But I don't know, they got me in your account. I understand. I'm just. No, it's there. That's also the time myself.
Hey, Mr. Lowe.
Because that was the last one. Right. I understand. I think we're gonna do that. I'm not the one that involved. No, I don't think I'll say something about it. So we can get on the track. Then we just don't go. All this good. So who's going to preach? Today I want to ask you. I said, I want to. That's what I'm saying.
Mr. Schmidt, you ready?
Yes, sir. Judge, we're set to go with pretrial. Mr.
Yeah, who's your client?
Andre Davis. CR 23-00027.
All right, thank you, sir. Go ahead. Set for pretrial. I'm with you.
Pretrial judge, there was, Mr. Davis had sent some correspondence to the court, which I've had an opportunity to review. I think I've addressed that with Mr. Davis here, today. Ultimately, what I would ask is the court to reset this for an additional pretrial hearing. I tried to pull Mr. Davis on Monday to review the discovery with him, but he was housed in Henderson County, so we're going to make something happen so that he has the opportunity to view videos and read the reports before we proceed. So from that perspective, I think we're good to go forward, except for that we would ask for an additional pretrial setting.
The objection from the state.
They would have no objection, Your Honor.
All right, and the court will grant that request. The court sets Mr. Davis for an additional pretrial setting on June 27th. It'll be at 1:30. Unless Mr. Davis.
Yes, sir.
Do you have anyone else that's ready?
Not yet.
Okay.
Oh, yeah.
So that is Richard Schmidt. Richard, this is our new deputy. This is Fabio Martinez.
Oh, I like it. You can bail it or you can go and just bail it?
Can we get this? Hey, guys. Thank you. Back. Well, they didn't put it back. Thank you. Ma'am, let me get you over here, please. Thank you. Yes, sir. Down the road, you know, back to
Mr. Schmidt, who are you ready on?
Get you done.
You said Miss Devlin? You said Miss Devlin, is that correct?
That's correct.
All right, this is CR 2347. Set for arraignment. Go ahead.
Good job. I think it was April 21st. Ms. Devlin was deemed incompetent to stand trial. The report was forwarded to me and I reviewed that. At the time, I concurred with those findings. Ms. Devlin is medicated right now, and having talked with her here a few minutes ago, she's doing much better. So I'm not prepared to go forward with an arraignment at this time. However, I am going to pull her on Monday and discuss with her case. And if it appears to me her mental health has improved to the point where we can have a cogent conversation, then I'm going to ask the court to have her reevaluated so we can move the criminal case forward. But she has made vast improvements in a short time.
All right, then the court will reset Ms. Devlin then for competency status and possible arraignment on June 27th. If that gives you enough time.
Yes, sir.
And Mr. Schmidt, if you can, after your meeting with Ms. Devlin, if you are of that opinion and request a reevaluation, if you'll just contact Ms. Abraham, we can get that done. Hopefully have some kind of response before our next court hearing.
Yes, sir. Sir. Yes.
Who'd you like next? Who is that?
Mr. Cronin.
Cronin. All right, this is cause number CR 22-322, State versus Joseph Paul Cronin.
Judge, we were prepared to plea today, and I have the paperwork, and I was meeting with Mr. Cronin prior to the docket starting. Things came to my attention that made me very uncomfortable with proceeding to a plea at this point. Mr. Cronin was prepared to go forward, but I could not allow that under the circumstances. There are some things that I need to follow up with. I'd ask if the court would to set Mr. Cronin on the 30th docket. I'm not certain that it will be a plea or not.
at this point, based on what I've learned. But we will have that answer for the DA and be prepared on that day. It'll either be a plea judge or we'll announce ready for trial on that day.
Okay, court will set Mr. Cronin then on May 30th. What's the date? Court will set Mr. Cronin on its evidentiary docket, which is May 30th, set it for final docket call. Who'd you like next?
Right, Carol.
Mr. Carroll, if you'll come forward. This is cause number CR 21-208.
That's correct, Judge. I believe we're here on state's motion to adjudicate. Was recently appointed to represent. We've met this past Monday. Haven't had an opportunity to discuss with the state, but briefly on a resolution, and we'd ask that this be reset.
All right, court will set Mr. Carroll on the contested docket on May 30th. Who's next?
Richard Bonin.
Richard Raymond Bonin, CR 22-353.
We're set for a docket call, Judge. I'm gonna ask for an additional docket call. I was discussing Mr. Bone's case with Mr. Woodwhite I believe it was the end of last week. I'm not sure if we're making progress, but I think we will. There's some things that I'm trying to look into to provide to Mr. Woodwhite, so hopefully resolve the case. And the court would indulge us in additional docket call. I appreciate it.
Yeah, also just for the court's information, we are reaching out to our victim. We are having some difficulty in locating her. We believe she has moved out of state. So we're working on that. So we would be unopposed to a final docket call, see where we need to actually end up with this case.
All right, court will set Mr. Bonin then for a final docket call on May 30th. Next, Mr. Chairman.
Mr. Gerald Powell.
Gerald Wayne Powell, CR 21-235. So that we're set for status on Dr. Proctor's report.
That's correct, Judge. I have not or am unaware whether or not Dr. Proctor has submitted a report, so I defer to the state on that.
Judge, I am not aware of any updates. I don't believe there are any. I sent a message in to Ms. Curry and I have not received a response back on whether she's heard from Dr. Proctor or not. So at this point, let me double check, but unless something has come in the last few days, I don't believe that we're probably going to have something from Dr. Proctor.
And I do know I spoke with Ms. Curry, I believe it was last week. And at that point, she didn't have anything from him, so it would have to have been pretty recently.
So what do the parties propose that we do?
Well, Judge, I don't have a proposal, except for that I do understand that, you know, under the circumstances, given our defense and the notices we filed, you know, the state's over a barrel. They're entitled to an evaluation. And I suspect that it would probably be in everyone's best interest for myself and Ms. Curry and perhaps the rest of the crew to sit around a table and hash that out. But at this point, you know, absent, I mean, and I also know that Dr. Proctor has met with Mr. Powell multiple times. He's run Mr. Powell through a battery of tests. So report or not, I know that he has done a lot of theoretical work towards the insanity evaluation. So it would be a shame to go this long and not have a final product, considering the expense and the time that's been put into it. But I don't have the ability to expedite that from my position.
I think we do have that. I think both of y'all have that ability. It's called the power of subpoena. And we subpoena Dr. Proctor to the next court hearing. And we get testimony from him about, do you have a report? Do you not have a report? Why do you not have a report? Is that something y'all want to do? State that you're witness.
Judge, I would propose that we set this for the 30th, the next contested docket. I think at this point, that sounds like a reasonable way forward to me. I will defer to whatever Ms. Curry wants to do, but let's set it for the 30th. Let's plan on that. And if Ms. Curry wants to proceed, otherwise, I will have her let you and Mr. Schmidt know what we do intend to do before the 30th.
Okay. What I don't want to do is set it for the 30th. No one subpoena Dr. Proctor, and we don't have a report on the 30th, and basically be in the same position that we're in now. So either we subpoena him or we abandon him, and then y'all figure out how y'all want to deal with that. What I want to guard against is continuing to delay this case, the trial of this case. Understand that state's entitled to seek an expert and get an opinion. Understand that Mr. Schmidt now may want that product of or Dr. Proctor. Could be something mitigating or exculpatory in there. So I understand that. So we've got to get at that so that we can move forward in this case. I just want to make sure that we're all on the same page as to kind of what's expected on the 30th.
I understand, Judge.
Okay. All right, court sets Mr. Powell in for final status on Dr. We'll call it the second final hearing on Dr. Proctor's report on May 30th. That'll be at 1:30. And if Dr. Proctor needs to, if we work this out, and he needs to appear via Zoom or something of that nature, let me know. We can get that set up as well.
Okay, thank you.
Your Honor, I'm sorry, we're having to do a double check of our list and see who's what and who's left and who's where.
Who has been on first for a very long time, but I'll let you check your list.
So I didn't check who off, so I need to.
Who's on first?
I'll put this on mute. I'm gonna step back and swap some bodies.
Mr. Manning, you ready?
Yes, Judge.
Who are you ready on?
We can start with Mr. Hicks.
Since cause numbers CR 22-356 and 399, State versus Braylon Hicks. Except for pretrial, go ahead, Mr. Manning.
Yes, Judge. So we've had an opportunity to go over a good portion of the discovery. At this time, we're going to announce that we have no contested pretrial issues and requests to be set on docket call.
All right, court finding that there are no contested pretrial issues sets Mr. Hicks for docket call. About June 15th.
Judge, I believe that will work. Let me double check. I just had a trial move. Judge, that will work.
Okay. All right, Mr. Hicks is set for docket call June 15th. All right, who do you have now, Mr.
Next, ready on Mr. Cody Wellborn.
Cody Lee Wellborn, CR 22-32-33, set for pretrial. Go ahead, Mr. Manning.
Judge, unfortunately, I've not been able to have an opportunity to go over all the discovery or any of the discovery with Mr. Wellborn at this point in time. I've talked with him and he'd like to go over that. So I request to have an opportunity to go over that with him this Friday and reset his case for pretrial.
All right, court will set Mr. Wellborn for an additional pretrial hearing on June 15th. At 1:30. Who's next?
Judge, ready on Mr. Ehrenfeld.
All right, Mr. Ehrenfeld. This is cause number CR 22-270, State versus Kevin Max Ehrenfeld. Mr. Ehrenfeld, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help me God.
Yes.
All right, thank you. Lower your hand. Make sure you speak up loudly and clearly for me. Your name is Kevin Max Ehrenfeld, is that correct? Mr. Ehrenfeld, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes, sir.
You feel like you've had enough time to talk to him about your case and that you've had all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
Mr. Manning, do you believe Mr. Ehrenfeld to be competent?
Yes, Judge.
All right, and have you also explained to him the advantages and disadvantages of a deferred adjudication plea?
I have.
Let's see, Mr. Ehrenfeld, you were originally charged with aggravated assault against a public servant, a first-degree felony. However, it appears today that the state's recommendation in your plea agreement is that that charge be changed to that of obstructing a highway. Let's see, so obstruct a highway passageway for emergency vehicle, a state jail felony, which has a range of punishment of not less than 6 months in jail or more than 2 years. I'm sorry, 6 months in prison or more than 2 years in prison, and a fine not to exceed $10,000. I see that the plea agreement in your case is that upon your plea of guilt, the state's recommending that your guilt be deferred on that offense that you're that you be placed on 4 years community supervision. That and they would be dismissing several charges, 2022-365 of trespass, DA 2022-453 accident involving damage, DA 2022-451 deadly conduct, and DA 2022-454 accident involving damage. In addition, you would have $290 in court costs, $575 in reimbursement fees. Mr. Ehrenfeld, is that your understanding of the plea agreement?
Yes, sir.
That's what you want the court to approve.
Yes, sir.
And you understand, Mr. Ehrenfeld, that if the court approves this agreement, you'll be placed on conditions of community supervision. If at any time during your period of community supervision, you violate either any term, a single term, multiple terms of that condition, the state can file a motion to adjudicate your guilt and bring you back to court. And if they prove to the court during a hearing with evidence that you have violated your community supervision, the court could do a multitude of things, including convicting you of this offense, revoking your community supervision, and sentencing you anywhere between the minimum 6 months all the way up to the maximum 2 years. Understanding that, you still wish to go forward?
Yes, sir.
All right, and Mr. Ehrenfeld, and let me ask Mr. Manning, do you believe Mr. Ehrenfeld to be competent today?
Judge, I do. He's had an opportunity to go over the discovery, to assert certain defenses to some of the other charges and to help assist in his defense and leading to this resolution of this plea agreement. Additionally, Judge, he's had several questions that I've been able to answer throughout regarding the conditions of probation as well as procedure. And I believe he is competent to proceed with this plea today.
Is this a lesser included offense of aggravated assault of a public servant?
Judge, I don't believe it falls as a lesser included, no, Judge.
So how did we get here today? He was charged with ag assault against public servant. There's not a new filing, correct? It's under the same cause number. How do we get from a first degree ag assault public servant to a state jail obstruction of a highway that's not a lesser?
Judge, my understanding was we were. I'll let the state answer.
No, Mr. Manning and I discussed this charge as a resolution. I guess we just, based on our agreement, we were going to change the charge. Yeah, we have not filed a new charge against him and dismissed this charge. I guess we would argue that we could proceed under the same arrest, the TRN, so it doesn't add additional entries onto Mr. Ehrenfeld's criminal history. State would be willing to file an information very, very quickly so we could get this resolved.
And Judge, my understanding was, I apologize, I thought the information had been filed already, because it said that this was proceeding under the same agreement we had for the charge.
Yeah, y'all both agree with me though that we can't plead him to a changed offense that's not already included within the primary charge. We're agreed on that.
That'd be my.
Yes, Judge.
So we'll need to reset this, either get that file today. I've got a failing law man. I'm gonna take up about 3:30.
Judge, I can get it filed in just in a minute. Hopefully that would give the clerks enough time to do that if Mr. Manning's willing to remain around so we can get this resolved.
Because of the time issues that we discussed earlier, I don't mind waiting for the state, and we would waive obviously on the information. Yeah, if we can get that done, that I think that'd be in the best interest of my client.
So we'll need to change all the plea papers to the new number. So we'll need a new.
We'll do
step.
that.
We need to sign and swear the new step. All right, Mr. Ehrenfeld, we're going to call your case back up here shortly. Okay.
Yes, sir.
Mr. Schmidt, who are you ready?
Michael Covey.
Michael Shane Covey, CR 2154. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, I think we're also have another setting. It's on your docket. I can't recall what it was. I've been in contact with Ms. Taberham about Mr. Covey. Previously, if the court will recall, there was a bed available for Northeast Texas, I believe. We PR bonded Mr. Covey out. He was transported to that facility. He was discharged from that facility. He met with me at my office. And then when I spoke with Ms. Taberham, she had told me that Terrell State had requested that he be benched back here. So we were confused as to how he went from Northeast Texas on a PR bond civil commit to being benched by Terrell State. He's signed a release so that the court can obtain the records from that facility. But ultimately, it's my planning until I get further information that Mr. Covey should still be on a PR bond. And one of the things that he was in the process of doing, number one, he went to Terrell State on his own accord because the medications he was released with were insufficient. And he was aware of that. So he was taking proactive steps towards getting that tended to, but one of the things that we're trying to do is get him to the Andrews Center to get the appropriate medication to address some of the psychotic issues that he was having and is aware of. So that's kind of, I think, why we're here today, because he went from Northeast Texas to Freedom to Terrell back to jail. And the MTR is still set for a later date.
Yeah, I've talked with Ms. Taberham about this. My recollection is, as you have stated, is that Mr. Covey was released and as a condition of his bail was to attend that Northeast Texas treatment facility and follow the recommendations. I think the information that was communicated to us, whether rightly or wrongly, it was nevertheless communicated that he left that facility and then was placed into Terrell State Hospital. So at that time, it appeared to the court, it seemed to the court that he had violated the condition of his bail. Now, if I can get more information from Northeast Texas to show me that he did follow their recommendations, then obviously, yes, we can reinstate bail. My additional concern, though, is that if he's checked himself into Terrell State Hospital, he must have met some kind of criteria that would make me have a concern as to whether or not he should be on bail if he's all state.
I understand the court's concern. One of the things that prior to going to Terrell State, Mr. Covey did follow my instructions and met with me at my office. And we had arranged a game plan for him to proceed to make sure that his mental health issues didn't fall through the cracks. And he had made active steps to do that. Then he had an acute episode and took himself to the Wills Point PD and ultimately asked them to take him to Terrell State. So he was aware that whatever was being dealt with at Northeast Texas was insufficient. And the episode was an acute episode. So we understand the court's concern and we've addressed that with him and we've discussed it, but administratively, we're still unclear. I guess the court is stating that the court revoked his bond in the belief that he was in violation for not complying with, because that's what I was unclear on.
Yes, that was the court's belief, but what you stated is that you have paperwork that shows that he was discharged from that treatment facility that he was supposed to go to.
No, sir, I don't have paperwork. That was the gist of my conversation with Mr. Covey and his belief as to what occurred. And I know that Ms. Taberham is in the process of retrieving those documents and Mr. Covey did sign a HIPAA release and she's in possession of that. So I would expect those documents to be forthcoming pretty quickly. And I would
My mistake. I thought you said that he was discharged from Northeast Texas.
That's my understanding as well, that he was released.
Okay, I thought you were basing that on information you got from the hospital.
No, he had documents when he met with me in my office, but he doesn't have them anymore. I haven't spoken with Terrell State, because that's different.
Sure, yeah. Carroll State, I'm not, my revocation of his bond was the fact that he was no longer in that treatment facility in Northeast Texas. And there was no reason or that the court knew that he was discharged after he had followed their recommendations. It appeared to me, my belief is that he had left that facility, as it's not a lockdown facility, and
Yeah.
that he didn't follow the recommendations.
I don't think that's the case, Judge, and on a civil commit, you know, they rarely hold them longer than 48 hours. They'll stabilize with meds and boot them. I mean, it's pretty standard procedure. So when I saw him in my office, I was not surprised that he'd already been released. He did have medical paperwork with him at the time, and I didn't make copies of them, so I don't recall exactly what they said, but it's his understanding that he was discharged and with a certain amount of meds, and the Terrell State issue followed up. That was, like I explained, happened later, but so based on my understanding, unless there's something lost in the shuffle, he was participated, discharged, and then we were going to follow up with the Andrews Center to get the appropriate medications to keep him stable. So that's my understanding.
Okay, then what I want to do is I want to wait on the records since Mr. Covey can't produce them. I want to wait on the records being produced by the Northeast Texas Treatment Facility, wherever he was. Once we can get our hands on that, and if that justifies Mr. Covey being out and then where he's at now, then court will consider reinstating his personal bond.
Yes, sir. And also that from that perspective, from the mental health perspective, there's a few other things that I would need to follow up on prior to proceeding on the motion to revoke. Either way, and I'll speak with the state about that, but I do believe we already have a setting for Mr. Covey. I don't know right off the top of my head when that is.
Judge, I believe it's 5/25, according to the docket.
And I'd ask that we pull it off that docket and put it on the 30th, if that would be okay.
Let's do that, because I don't think that I'm going to be here on 5/25. Visiting judge here that week, so might be best not to deal with Mr. Covey that is on that date. So court will set Mr. Covey then for the 5:30 date. Motion to revoke. In the meantime, Mr. Schmidt, is he requesting to be evaluated by the Andrews Center?
Yes, sir. Yes, sir. I believe that there are certain medications that he is lacking that he needs. We still have auditory and visual hallucinations that are causing him quite a bit of trouble. That's why we're in the situation we're in now.
Do you know if he's currently a patient of the Andrews Center?
All right, so he had been. I'm not sure what the current status is.
If he had been, then they'll have records on it, and that'll make the process easier. So just tape your hands here with me, or we're going to process that request, contact the Andrews Center. So while we're waiting, we won't be losing time on getting them set up for minutes.
Sounds good. Thank you.
I'll see everybody back on the 30th, and I'll have Ms. Abraham check with that facility and see if we can get an ETA on medical records.
Yes, sir. I think that's it.
All right, thank you, Mr. Covey. We'll see you back on May 30th.
Okay. Yeah. I believe that's all I have.
All right, thank you. Mr. Schmidt. Ms. Abraham says that you're not free to go.
I beg to differ.
That's just what she says. I'm just the middleman. Don't shoot the messenger. Let's see. There's a Mr. Brad Rodriguez that's there in jail court. You've been appointed to today, and I think she's about to send the stuff over to you. It's a motion to adjudicate.
Yes, sir.
Do you want to talk to him first, or do you want me to just reset?
Yeah, I'll talk to him.
Brad Rodriguez. eucalyptus forest. Eucalyptus forest. That's where you go to get eucalyptus. Mr. Schmidt, you ready? Yeah, you're on. All right, there we go. All right, Mr. Rodriguez, the court has found you to be indigent upon your application for appointed counsel. Court has appointed the Honorable Richard Schmidt to represent you. Mr. Schmidt, you want me to set this on the contested docket for June 29th?
Sure. June 29th.
Or do you want it on May 30th?
No, sir, I don't think so. I briefly went over the state's motion with Mr. Rodriguez, and I'm gonna be with him on Monday, and I think we're gonna require a little bit of time.
All right, court says Mr. Rodriguez, his motion to adjudicate for hearing on the contested docket, June 29th. If an agreement is reached, Mr. Schmidt, you know, of course, you can always contact the court. We can move it up for you.
Yes, sir. Yes, sir. Thank you, sir. Yep.
Mr. Woodwine, did you ever find out anything on Mr. Joshua Davis?
Yes, Your Honor. I contacted the Henderson County Jail. And they do not currently have a hold from Van Zandt County. He is currently being held on a Kaufman County failed to register as a sex offender, a parole violation with the Texas Department of Pardons and Paroles, and currently has a federal detainer from the U.S. District Court. But he is not currently, according to Henderson County, being held on a Van Zandt County charge.
But he is.
He is in fact in their custody. Yes, Your Honor.
All right. Does the state have any intentions on proceeding before the federal authorities or Kaufman or anyone else, or do y'all want to just get money?
Judge, I think it's these Van Zandt County Criminal District Attorney's Office is comfortable waiting our turn in line, seeing how his other cases resolve. If we could set it for a status, maybe 60 days out, seeing where everything else looks like it's headed, and then we can make determinations whether we are going to continue prosecution here or dismiss our case because he is resolving his cases in those other jurisdictions.
All right, court will set Mr. Davis for status on Tuesday, July 11th.
Hey, did you have insurance on that vehicle?
All right, Mr. Manning, did the new charging instrument get filed to get a cost number?
Yes, Judge, we have CR 23-00106, and we have also executed a waiver of information. And we also waive the arraignment in that cause.
All right, so waiver of indictment and waiver of arraignment. All right, so let the record reflect that we are back on the record CR 22-270. The court finds that Mr. Ehrenfeld has been charged now by information with a charge of a state jail felony obstructing a highway or passageway for emergency vehicle. Court finds that the defendant is waiving his right to indictment in that case, and you said you have executed a waiver in writing on that. Is that correct?
That's correct, Judge.
Okay, so Mr. Ehrenfeld, I've already placed you under oath. I've already gone over the plea agreement. The only change that's being made in this case for your purposes is that the former charge of aggravated assault of a public servant, a first-degree felony, I assume is going to be dismissed with your plea in this case, or 1245, at least with your plea in this case. So the charge has been changed to a state jail felony obstruction of a highway or passageway for emergency vehicle. So Mr. Ehrenfeld, I can't recall, Mr. Manning, did I already have to plead guilty to that charge?
No, Judge, last you had checked, we were discussing competency, and you had found him competent, and we're getting ready to proceed to pronunciation.
Okay. All right. So Mr. Ehrenfeld, you are charged by information with the offense of obstructing highway or passageway, a state jail felony. A state jail felony has a range of punishment, minimum 6 months to a maximum 2 years in state jail prison, and a fine if imposed up to $10,000. I see here that the plea agreement and recommendation of the state is that upon your pleading guilty to that offense, that they would recommend the court defer a finding of guilt, placing you on community supervision for 4 years, having you pay court costs, reimbursement fees, and the state would be dismissing several charges: criminal trespass, accident involving damage, daily conduct, and another accident involving damage. Is that your understanding of the plea agreement, Mr. Ehrenfeld?
Yes, sir.
All right. And you have talked to Mr. Manning, and you are understanding today that you are waiving your right to an indictment in order to plead to this charge. Is that correct?
Yes, sir.
You understand that no person in Texas can be brought to trial on a felony offense without the case going to the grand jury. And the grand jury is that body of people who review the evidence as presented by the state, and they make a determination whether there's enough evidence to go forward. You understand that you are waiving your right to that grand jury review of your case. Is that correct? And you are waiving that right to a jury. You're waiving that right of indictment and waiving your right to present your case to the grand jury, because this is what you want to do, and you're doing so intentionally, knowingly, and voluntarily. Is that correct?
Yes, sir.
All right. And Mr. Manning, just for record purposes, you do believe that Mr. Ehrenfeld is competent and that he's entering in his plea intentionally, knowingly, and voluntarily?
Yes, Judge, he's still competent.
Okay. All right, then Mr. Ehrenfeld, understanding the range of punishment, understanding the plea agreement, you also understand that if you are placed on deferred community supervision, that if you violate any of the terms and conditions of your community supervision, the state can file a motion to adjudicate your guilt. That means to convict you. The court could hear their evidence, and if I find that you violate any of the terms of your community supervision, then the court could conduct a hearing and revoke your community supervision, adjudicate your guilt, and sentence you to prison anywhere between the minimum 6 months to the maximum 2 years. Is that correct?
Yes, sir.
You understand that?
Yes, I do.
All right, then how do you plead, Mr. Ehrenfeld, to obstructing a highway passageway for emergency vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, the state's evidence.
I'm sorry, Judge, there's a lot of noise here. What was that?
The objection to the state's evidence.
No objection to states one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, just for the record purposes, state will be e-filing as soon as this hearing's over. A motion to dismiss CR 22-00270 in conjunction with this plea. And with that, state would have nothing further when rest and close.
Thank you, Mr. Woodwine. Anything further from the defense, Mr. Manning?
Judge, as we were talking about off the record previously, Mr. Ehrenfeld is, as part of his conditions of probation here in Van Zandt County, as well as Rains County, he is going to be going to the Dallas VA for a program for homeless veterans. And he has been offered a ride from the sheriff's office. He is, as a condition of his probation, going to remain here in Van Zandt County Jail until Thursday, when we've been told he'll be able to be transported from the Van Zandt County Jail to the Dallas VA. And we've communicated that he understands and waives any objection to any error that could be incurred by that. But he also understands that it's part of his conditions that he is to comply with to remain here until spot becomes available or transportation becomes available on Thursday.
All right, so Mr. Ehrenfeld, you understand that you, after today, will be placed on community supervision, and that there may not be a legal ground in which we could hold you in our custody. And so today you would be waiving the right to be freed from custody in order to be transferred by the county, the Van Zandt County Sheriff's Department, to your VA placement. Is that correct?
Yes, sir. That's what I need.
So you're agreeing to remain in custody so that Van Zandt County can transport you so that you can comply with your conditions of community supervision. Is that correct?
Yes, sir. Fill up.
All right, then if there's nothing further, then the court's going to review the evidence. All right, the court has reviewed the evidence. The court finds that there is sufficient evidence to convict Mr. Ehrenfeld of this offense. The court will follow the plea agreement and the recommendation of the state. The court hereby defers the finding of guilt, places Mr. Ehrenfeld on 4 years community supervision for the offense of obstructing a highway or passageway for an emergency vehicle. The court dismisses under section 1245. Cause number 2022-365, a criminal trespass, DA 2022-453, accident involving damage, DA 2022-0451, deadly conduct, and DA 2022-454, accident involving damage. Court imposes court costs of reimbursement fees of $575. Mr. Ehrenfeld, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. I'm going to have you step over with the deputy to be fingerprinted, and I hope you do well in your placement with the VA program.
Thank you, Your Honor.
Mr. Manning.
Judge, my understanding that Mr. Boylan is going to be brought up once the doctor is available. If that's still all right with the court. I'm not sure what the doctor status is.
Yeah, I believe that Dr. Foreman was gonna zoom in at 4:30 and said he'd be willing to be part of the hearing.
Okay, I'll be standing by here, whenever the court's ready.
Mr. Woodwine, Ms. Taberham says she just emailed you the application for order to administer psychoactive medication. I believe that this just originated this concern about Mr. Boylan. So I know there's not much notice to the state. I believe that Mr. Meany is going to be in agreement with that, and Dr. Corman is already opined. So anyway, this has been sent to you. And so we're gonna have Dr. Foreman get on and we're gonna see if we can have the hearing, the grounds are met, and consider forcing psychoactive medication for Mr. Boylan so he doesn't continue to deteriorate.
Yes, Your Honor.
All right, so she said she emailed that to you. If you don't have it, let me know.
I just received it, Your Honor. We'll review it shortly.
I appreciate it. Good afternoon, Dr. Corman. How are you, sir?
Can you hear me?
Yes, sir. I can hear you now. How are you?
Very good, thank you.
All right, let's see. Mr. Manning, do we have Mr. Boylan in the courtroom yet?
Not yet, Judge. I was wanting to go through a couple procedural issues, as this is my first time doing a 46B hearing. I was looking over the statute and it appears there's a requirement for under D,
Let's do this. Tell me what statute you're reading.
46B.
46. All right, I don't have my code. Give me a second. Let me go get it. I was reading under health and safety code. Hang on. Let me go get my book.
Okay. Are you still there?
Yes, sir.
Okay. Do you have a copy of that motion that you filed or that was filed?
I do. I mean, it was just emailed to me three minutes ago.
Okay, I'm just trying to figure out 46B looks to be the applicable statute. And I'm seeing that there appears there may need two physicians, one who's a physician at or with the applicable facility program who's prescribing the medication, and the other who is not otherwise involved in proceeding against the defendant.
Hang on, Mr. Manning, but I am familiar with that. So this is a physician's application. This is not an application filed by the state.
Okay.
Yeah, so this was filed by Dr. Corman. The state didn't file this. So I have read over those statutory requirements. So this is a proceeding under 574.104 physician's application for order to authorize psychoactive medication.
Excellent. Yes.
I think that now the due process concerns is why the legislature put the requirement of two physician certificates, in that it would be the state seeking to force meds for purposes of continuing the prosecution versus a healthcare provider like Dr. That's, I haven't read the legislative intent behind that, but that's what I believe through my research is the safeguard for the additional one.
Well, and at this point, I haven't been served with a copy of the motion, so I was just kind of going off of my limited understanding of the code in regards to court order medication.
Yeah, do you want to take a moment? I can zip you a copy of this statute that goes
Well,
over.
copy of the motion just so I can track with procedurally where we're going.
So you don't have Dr. Corman's application.
I do not.
Okay, sure. All right, give me just a minute and I'll have Ms. Abraham send that over along with a copy of chapter 574.
Thank you, Judge.
All right, so Dr. Corman, if you want to hang tight, I appreciate it. You can turn
Sure.
off if you want to, whatever you want to do. It'll take just a minute and then we'll proceed.
I'll be right here.
Appreciate you sticking around late today.
No problem.
Mr. Manning, do you need me? Or
Well,
do you
I'm
need Judge?
as you know, we're getting him dressed as we speak. So he may be here in just a second.
Okay, I forward you the application, but I think Ms. Abraham's going to do that. Excuse me, as well as chapter of 574 of the Health and Safety Code is what we're proceeding under, Mr. Manning.
Okay.
You don't need Miss Lisa anymore.
Well, I don't think so.
Guys, I think he's looking up some stuff right now. If y'all would like to sit down, whatever y'all preference is, but.
Hey, Dr. Davis. How you doing today? Because you were new to me.
How'd you get all wet today?
Took a shower.
You took a shower? That's a lot of water.
I'm not thinking I got here for take all medication. My blood pressure 60 was 60.
Is the rest of your cell wet too?
Where the shower was,
Just the shower?
because I forgot how I was getting sick. They're poisonous with the food and stuff. It's out of date. And I caught it when I first came in. And this man is not even supposed to be a lawyer or district attorney in the jail board from Johnson County, which is Corpus Christi, Texas, Navarro County.
How'd your clothes get all wet?
Drying off in the shower.
Or you dried off with your clothes?
I didn't get off all the way through Judge Christie.
But were you using your clothes to dry off?
Mm.
What kind of makeup it was?
Good do ya. And the way putting Miss Mark, come on. Hey, Miss Taylor, how you doing?
I'm doing well, sir.
I got you caught, Mister. You can put you in prison too. You, this one, all you came from Navarro County, place you in prison, but 3 people. And they all, 4 people in this family. Mr. Patterson, Mr. Baker, Mr. Stephanie Ashley, which is Ashley, my girlfriend, Shelley Ashley, and the one that's not going is going to be you and you and Miss Heather. And I think all of you, senior FBI cop yourself. Right here in Johnson County.
And
Hey.
where?
Hmm?
Where?
Right here in Johnson County, Texas.
Dallas
Address,
County?
Johnson County.
Johnson County?
Address right here. 1800 North Ridgemont Street, Johnson County, Cleveland, Texas, 765. All right, 76103.
Is that home for you?
Both zip code. And the other one is 76033.
Who else is there at home?
Now I'm a family right here. I know.
Who's that? Who's your family?
Chapman family.
Your mom?
Right.
Your wife?
We go to the same church. My wife is, her mother is with, my grandpa passed. He told her, he takes my name, to send me further Brown. I've never done anything to any kids.
Where's your mom?
Mama, over there in Selma, my grandma, in safe still.
What about your dad?
Same place,
Same place?
all with the family,
Do you have any brothers and sisters?
a whole bunch,
Whole bunch? Where are they?
all right here in one place. Cause didn't they, and then me right there.
In Johnson County?
And Johnson County Jail. Because there's one officer, and I caught him myself. I showed that evidence, Mr. Tony about the on the court docket, the high caught it.
Hey, Mr. Boylan, how are you doing today, sir?
Good. How you doing today, my friend?
Hey, I'm doing fine. I'm doing fine. It's good to see you. I need to talk to these other gentlemen, so let's be quiet for just a second, okay?
Okay.
And then I'm going to talk to you for a little bit. I want to see how you're doing, okay? So give me just a few minutes. Let me talk to these other gentlemen, and then you and I are going to talk, okay?
Okay.
Thank you, sir. All right, this is the state of Texas versus Gerald Boylan. And today the court has before it an application for order to administer psychoactive medication filed by Dr. David Corman. Is the state ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed, Mr. Manning?
Yes, Judge.
All right, go ahead, Mr. White.
State would call Dr. David Corman.
All right, Dr. Corman, sir, if you'll raise your hand, I'm going to place you. Dr. Corman, do you swear that the testimony you provide to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, Dr. Corman. You may lower your hand. Go ahead, Mr. Woodwhite.
Thank you, Your Honor. Would you please state your name for the record?
David Corman.
And Dr.
MD.
Corman, how are you? I'm sorry, what?
David Corman, MD.
Thank you. And how are you currently employed, sir?
Well, I work at a couple of community mental health centers, one of which is the Andrews Center in Canton.
Okay. And have you evaluated a Gerald Boylan?
Yes, I have.
Okay. And when did you evaluate Mr. Boylan?
I saw Mr. Boylan on September. Oh no, I'm sorry. The date would have been January 10th, I guess.
And Dr. Corman, you're aware.
Sorry, forgive me. I'm looking at the wrong chart here. Let me pull him up real quick. It was April 11, 2023.
And Dr. Corman, you are aware that he is subject to an order that he is incompetent to stand trial currently. Is that correct?
Yes.
And based on your evaluation, what has he been diagnosed with?
Bipolar disorder.
And he is he's been found incompetent, and you have on that date, I believe April 11th, you filed an application to prescribe medication.
Yes.
Is that correct?
Yes.
And what would those medications be?
Well, he had previously been on antidepressant, psychotic, and mood stabilizing medicines, and I applied to reinstate the prior regimen of those three medicines.
And in what method would those be administered to Mr. Boylan?
Well, they would be administered by mouth, but under the court order, if he refused them, they might be administered intramuscularly by injection.
Those the current are those the customary methods of administering those medications?
Yes.
And would that be the least restrictive possible way that we could do that?
Yes.
And given his diagnosis and his mental state, do you believe that he would have a better prognosis prescribing those medications?
Yes, definitely.
And if those are not prescribed or not administered to him, is there a negative prognosis?
He's more likely to have psychotic regression and mood instability without medicine.
Because my doctor, I know.
Hang on, Mr. Boylan.
Okay.
We'll talk in just a minute.
Have you considered all the alternative possibilities to this? And this is the best medical treatment for Mr. Boylan?
Yes.
And you believe that this, the administering of those medications outweighs whatever risks to Mr. Boylan of not taking them?
Yes, I do believe that to be true.
And you believe that this is the least intrusive treatment for Mr. Boylan that we can
Yes.
realistically proceed on?
Yes, that's right.
Judge, state would pass the witness.
Mr. Manning.
Just briefly, Judge. Doctor, you talked about that it would be in his best interest to receive this medication because of the risk of regression. What risk would he be facing if he continued to not take the medication as prescribed?
Well, he'll continue to have impaired judgment and impaired reality contact and instability of mood, all of those symptoms would persist.
And could that place him or members of the jail staff at danger for physical harm?
I did not check the box that says that he would present a danger to self or others, but I did check the box that say he lacks capacity to make a decision regarding administering medicine in his own best interest.
Okay. And was that based on your own evaluation, or was that in conjunction with the evaluation previously done as part of his competency evaluation?
No, that's based on my own evaluation.
Okay. I pass on witness, Judge.
Mr. Woodward.
We have nothing further, Your Honor.
All right, Mr. Manning, do you want to call Mr. Boylan at all regarding his expressed preferences regarding treatment? Any religious beliefs, anything of that nature?
If I may just have a moment to speak to my client.
Yes.
No, sir.
He does not wish to be called.
Okay, I understand. Mr. Manning, I would like to, I think the court needs to hear from jail staff. Maybe we have some officers with us at this time that could give any information as to whether Mr. Boylan presents as a danger to himself or others because of a mental disorder or mental defect. So what I'm going to do is I'm going to take a recess for just a moment, and I'm going to ask that you inquire of these officers and any other officers, Deputy McLeish, you can assist Mr. Manning. I'm going to want to hear about that. I think it's necessary before a court can fully consider whether or not Mr. Boylan refuses to take these medications. If I can order that he be forced to take those. You understand what I'm saying?
I understand, Judge. I don't know, since it's the state's motion, I don't know if you would like for them to question those individuals as witnesses, or if you'd like for the defense to question, I could very well do that as well.
What I would like for you to do, Mr. Manning, is that as the defense attorney is just inquire as to whether or not there's any evidence that he would be
and Judge, I can go ahead and do that. I've been in touch with the jail staff.
That's what I was saying. I was going to take a recess and let you just inquire, and then you can report back to the court whether you think any evidence exists to that or not. And if there is, we can identify the witness and I can let the state question.
Yes, Judge.
All right, so I'm going to mute the jail court so you can have those discussions in private. Do you need more time, Mr. Manning?
No, Judge. I believe Sergeant Davis will be the one that will be testifying to those items.
Okay. And before we do that, let me ask Dr. Foreman. We haven't really defined danger as it's presented to us in health and safety code, but under the plain meaning of the word danger, Dr. Foreman, do you believe that the state that Mr. Boylan is in right now, if he refuses to take the medication as prescribed, that he presents a danger to himself?
I don't have any direct evidence that he is a danger to himself. And I would have to rely on reports from the jail staff to know if he is a danger to himself or others, based on behavior.
Thank you, Dr. Foreman. All right. So you said Sergeant Davis can give some testimony?
Yes, Judge.
All right. Sergeant Davis. You'll raise your right hand. I'm going to place you in the room. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help me God. All right. Thank you. You can lower your hand. Sergeant Davis, can you inform the court whether there exists any evidence that Mr. Boylan presents a danger to himself or others in the correction facility as a result of his mental disorder or mental defect, based on his refusal to take any medications prescribed to counter those mental defects or mental disorders?
Yes, sir. Last 3 weeks, he has become aggressive towards staff, medical and custody. When the food court has been open, he's reached out and tried to grab several different officers. Just today, when we tried to get him to respond to us, he woke up and tried to charge another officer with 2 other officers standing between him and that particular officer. Last week, he tried to charge the medical staff when he was unresponsive to us, trying to wake him up to take his medication.
Thank you, Sergeant Davis. Mr. Manning, would you like any questions, Sergeant Davis?
Yes, in specific concerns to my client's health, has there been periods of time throughout these 3 weeks where my client has refused to not only take his medication, but also ingest food or water?
Multiple times.
Multiple times?
I can
And
tell you how long exactly.
has,
Mr. Boylan, I want you to be quiet so that I can hear from these gentlemen, and then I'm going to give you a chance to say what you want to say, okay? All right, I need you to remain quiet so I can hear what these guys have to say. Go ahead, Mr. Manning.
and based on your training experience, is prolonged deprivation from food or water due to the health of the base being housed here?
Yes.
No other questions, Judge.
Would you like any questions to Sergeant Davis?
No, Your Honor, I think we've covered it.
All right, thank you. Okay. All right, is there any further evidence from the state, Mr. Boylan?
No, Your Honor. We would rest and close.
Thank you, sir. Anything further from the defense? Mr. Manning?
Nothing from the judge. I just want the court to take consideration of the court's file as how long Mr. Boylan has been in custody, as well as how long he's been waiting for bed in Terrell State.
All right, court will take judicial notice of the court's order finding Mr. Boylan to be incompetent. That was dated September 1st, 2022. The court will find Mr. Boylan has remained continuously in custody, waiting in bed at a hospital for purposes of restoration. Dr. Foreman, is there anything else that you think would be of import to know regarding Mr. Boylan that you haven't testified to today?
No.
Okay, thank you, sir. All right, then the court having considered, well, let me do this. I told Mr. Boylan I was going to hear from him. Mr. Boylan. All right, I want you to tell me about your medication. Why will you not take your medication?
Because I was I was getting mad, and my best friend Stephanie Miss Happy can back me up. I known them since I was in school. We start this team. Yeah.
Mr. Boylan, do you understand that the medications that Dr. Foreman has prescribed are medications that these doctors believe will help you, and they will help you so that you can understand what's going on in the case, so that you can help Mr. Manning, so that we can have a trial, and so that you can try to get out of the Van Zandt County Jail. Do you understand that? And you understand that if you don't take those medications, they can't help you. Do you understand that?
No, I have. I can tell you the address if you look up for my church family.
Mr. Manning, can you repeat what he said? It's coming through kind of garbled.
He was wanting to provide the court. He was attempting to provide the court the address for his church family.
Okay. All right, Mr. Boylan, anything else you want me to know before I make a decision on whether or not you understand? Do you understand, Mr. Boylan, that what may happen today is that I may order the nurses to give you the medication? If you refuse to take it, they may have to put you in a chair and strap you down and give you the medication so that we make sure that you're getting it. You understand that may happen? Do you understand that?
I couldn't ask about my sister. You back me up on. I fixed it just right. You smell like I don't get it. Trapped inside my stomach.
Okay. All right, then based on the evidence presented to the court today, the court finds that Mr. Gerald Boylan is under a court order to receive inpatient mental health services. That he is in custody awaiting a trial on a criminal proceeding, and he's been ordered to have mental health services inpatient within 6 months preceding the hearing. Under this section, the court also finds that Mr. Boylan lacks the capacity to make a decision regarding the administration of the proposed medication, and treatment with the proposed medication is in the best interest of Mr. Boylan. The court finds that Mr. Boylan has remained confined in the Van Zandt County Jail, a correctional facility, for a period exceeding 72 hours while awaiting transfer for competency restoration treatment, and that Mr. Boylan presents a danger to himself or others in the correctional facility as a result of a mental disorder or mental defect as determined under section 574.1065 of the Texas Health and Safety Code. The court has attempted to consider Mr. Boylan's express preferences regarding treatment with psychoactive medications, his religious risk and benefit from the perspective of the patient of taking the medication, the consequences to the patient if the psychoactive medication is not administered, and the prognosis of the patient if Mr. Boylan is treated with psychoactive medications. Court finds that there are no less intrusive treatments that are available that are likely to produce the same results as the psychoactive medication in the alternative, and less intrusive treatments likely to secure the patient's agreement to take the psychoactive medications are not available. So the court is hereby ordering the forced use of psychoactive medications should Mr. Boylan continue to refuse to take the medications as prescribed by Dr. David Corman, and the court is ordering the administration of the psychoactive medications found accompanying the application to order. Court is ordering the medications that are attached to the application for order to administer psychoactive medication as attached, the antidepressants, antipsychotics, and mood stabilizers indicated and selected by Dr. Foreman. Those are going to be ordered by the court's going to reduce all of this in a written order and provide this to both the state and the defense and the Van Zandt County Justice. And I believe that Mr. Boylan's already set for another hearing, so I don't think there's a need to set Mr. Boylan today. So court will provide that order to all parties, and we are adjourned in this hearing. Thank you, Dr.
Thank you, Your Honor.
Appreciate you being available today. Thank you, Mr.
Thank you, Your Honor.
Thank you to the jail staff. Thank you, Sergeant Davis.
Yes, sir.
All right, Deputy McLeish, anything further on the report stock?
Connor, we're done over here. Is there anything else we can assist you with?
Recorded.
No, I do not believe so. Thank you, Mr. Manning, for doing that on the fly. Appreciate that. No, I believe that concludes the court's afternoon docket. And if you don't have anything else, we'll be adjourned.
Thank you, Your Honor.